State of Utah versus Kevin Christensen, case number 251900580. Time set for initial appearance in the matter. Good afternoon, Mr. Bushell.
Good afternoon, Your Honor. Ryan Bushell for Kevin Christensen.
Your Honor, Carl Holland, Assistant Attorney General on behalf of the State of Utah.
Mr. Christensen, this is a new case, so I'm going to go over the charges against you, and then I'll cover some other things. What you've just been handed is the information. That's the formal statement of the charges against you. You've been charged with 2 counts of enticing a minor, second-degree felony. I would mention that all of these are alleged to have occurred on or about November 2nd of 2024. That doesn't mean it's a precise date, but those are approximate dates, at least, of the investigation. You also have 2 counts of dealing in materials harmful to a minor, third-degree felony. You have 3 counts of attempted aggravated sexual exploitation of a minor, second-degree felony on each of those, and a final count of obstruction of justice, third-degree felony. If there are any affidavits or recorded testimony in support of the charges against you, you or your attorney can obtain those pursuant to Rule 16 of the Utah Rules of Criminal Procedure. You're not required to make any statement regarding these charges, but if you choose to make a statement, those statements can be used against you in a court of law. That does not include statements to your attorney in private. Those statements are privileged and protected. You've been charged with 5 second-degree felonies. Each one of those carries anywhere from 1 to 15 years in prison and anywhere from $0 to $10,000 in fines. You also have 3 third-degree felonies. Each one of those carries anywhere from 0 to 5 years in prison and anywhere from $0 to $5,000 in fines. Do you understand the minimum and maximum penalties that could be imposed if you were convicted?
Yes.
Mr. Bushell, do you wish to have this go directly to a preliminary hearing or to a decision to prelim first?
Your Honor, if we may, a decision for preliminary hearing.
How far?
And if we could set that on the 24th of April, please, if that date's available on your calendar.
The court will continue the matter for decision to preliminary hearing April 24th at 2 o'clock.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Number 251900593, time set for decision of preliminary hearing in the matter. Good afternoon, Mr. Demler.
Good afternoon, Your Honor.
Good afternoon, Mr. Hansen. Mr. Demler.
Good afternoon. Thank you.
Yes, Your Honor, this is a case that was set over before Your Honor so that we could begin the process. I believe this is set for a decision to prelim. We'd like to set this for a further decision to prelim in this matter so we can get the discovery and have a chance to talk to the Attorney General's office about where this case is going to proceed to. The second issue here today is I'd like to make a motion to reinstate my client's bail in this matter. Your Honor, on this case, he was arrested on January 27, 2025. He was incarcerated in the Box Elder County Jail. Bail was set at $50,000. He posted that bail and was released. At that point in time, we feel that bail was appropriate. He's been a firefighter in the community. He's been a fire chief for 9 years in South Ogden, 16, 17 years in Logan, in Tremonton for 1.5 years. And other than being a fire chief in Jackson Hole for 5 to 6 years, he's been employed here for 30-something years. He owns his own house. He has substantial equity in the house. He has a wife and 2 daughters that live in this area as well. Quite frankly, he's not likely to flee, and we don't believe he's a danger to himself or others. I think that can be proven by the fact that he was released on January 27th did not abscond, did not have any other problems with his bail being posted until he was rearrested on March 10th, 2025. So we think not only was the jail or the bail that was set is appropriate in this matter, but we would ask that that be reinstated on this case and he be released on that bail. I'll submit that.
Mr. Demler, I'm trying to, what was the basis for the warrant after bail was posted?
You would have to ask probably the Attorney General's office, maybe have a better information of what they were thinking at that time.
Yes, Your Honor. Carl Holland, Assistant Attorney General on behalf of the state of Utah. The defendant was arrested in this case, as Mr. Demler stated, on January 27th and was released on bail. Following his release on bail, there were no criminal charges filed until March. Those charges were filed by the Attorney General's office, and at that time, the Attorney General's office also filed an affidavit in support of an arrest warrant in lieu of a summons due to the highly disturbing and dangerous sexual behavior that they found the defendant to be involved in, and then that warrant was issued by a judge.
Thank you. I can see that affidavit now. I was concerned because the way it got filed, it was filed quite a few entries apart from the warrant itself, so I
And Your
can see
Honor,
it now.
the reason for that, I'm sorry for interrupting, the reason it was filed that way is because of the fear of the defendant perhaps absconding or destroying evidence or information. That affidavit was signed by Judge Connor. It was filed under seal, and then when the first district court eventually all recused themselves from this case, then we refiled this as a new case here. And so the filings are a little bit different than what we're used to.
Understood.
I can address that, Your Honor.
Go ahead.
I think the Attorney General's office, when he was arrested on the 27th, had information with regards to his alleged offenses. That's what he was arrested for. They didn't file charges until March, I understand that. But it wasn't, they took all his devices, they had all those in their possession. They had all that information available to them when they made the original determination, and they didn't do anything for 2 months. There was no harm to anybody, nothing's alleged that there was any harm or danger of harm, and he did not flee. He was in contact with my office continually, wondering why charges hadn't been filed. And then they were filed 2 months later, and they do an arrest warrant. I think the $50,000 that he posted is adequate. He has numerous connections to the community, like I previously stated. And I don't think, if you look at the bail statute under 77-2201, my client has a right to bail. Furthermore, in my opinion, to modify any kind of bail or pretrial status under 77-2207, there's got to be a change of circumstances. And if you look at the definition of that under 77-2102, they haven't met any change of circumstances that would justify modifying the bail or changing the bail. They knew this information when they arrested him the first time. So I would assert that there's been no change of circumstances. The bail should be reinstated, and I'll submit it. Thank you.
Thank you. There are exceptions to the right to bail that are set forth in the Utah Code that you referenced, Mr. Demler. Mr. Hansen's been charged with 8 counts of aggravated sexual exploitation of a minor, all first-degree felonies. There is substantial evidence to support the charges and clear and convincing evidence to the court that Mr. Hansen would pose a danger to the community. I'm going to deny the request for bail at this time because there is an exception to the bail statute.
And we'd ask for another decision to prelim be set if we could, Your Honor.
And how far out do you need?
I can't do the April 24th date, so if we could have May 1st, is that a date that's available? Or
Court will continue Mr. Hansen's case to May 1st at 2 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
That's all I have. If I can be excused, Your
Yes,
Honor.
thank you.
Thank you.
You call it Colton Cleaning Bill, number 628.